I'm Bernard with Insurance Advisors Direct. I am the life and annuity manager here. And actually, we're doing a recap from our sales summit that we had back at the end of March. And one of the highlights of the sales summit was our estate planning opportunity with Scott Garcia. So we dragged Scott back out again to present. Uh, so Scott, here, take it away, my friend.
Well, thank you, Bernard. I really appreciate it. Thanks for setting up the meeting. We appreciate that. And welcome everybody from Insurance Advisors Direct. I met a lot of you there in Michigan, and I really had a good time there. What a great facility we were at. You guys were also very nice to me. I appreciate that. I've got about 11 business cards from people who were there. So I know there's a lot of new people on the call too. So let me just ask you a couple questions because I do what you guys do every day too. I'm actually in personal production. I'm in the field every day. And I'm also the national marketing director for our company, Integrated Trust Systems. You might want to write that down. Integrated Trust Systems. We've been around for almost 40 years, and we provide educational information on estate planning. Why that's important is this. You guys are financial professionals. However, most of your clients, just like most of my clients, or most people in Michigan or in St. Louis, where I'm from, don't know if they should have an estate plan. They think estate planning is for the rich and famous. We're going to talk a little bit about that today. Number two, once they realize they need an estate plan, they really don't know who to call. What attorney do I call? How do I know I'm getting a good deal? How do I know what they're doing? That's the second problem. Third problem is once they get an estate plan, they don't know what it should cost. Am I getting a fair deal? And then when they get it and they pay for it, they don't know how to change it. So estate planning is a very mysterious subject. Most people don't know a lot about estate planning. The reason I know that is I have an article in my office here, and the article says that every year 3 million people go through probate. If you take 3 million, put it in your phone calculator right now, and you divide 3 million by 50 states, and then divide that number by 260 working days a year, you'll find out the answer is 230. What that tells me is based on that 3 million statistic, if it is true, then there's 230 probate cases opened every day in every state. Write that down. 230, based on the average, 230 people will open a probate case in the beautiful state of Michigan today and in Missouri where I live. And it's going to happen Monday next week, Tuesday next week, Wednesday, Thursday, Friday, and so on. So what is probate? Probate is the government intervention on somebody's property and assets when they die if they don't have things set up properly. Let me give you a couple examples. How many of your clients, or maybe yourself, have a house and it's in their name and their spouse's name? Well, if they have a jointly owned property, if the man dies, the wife doesn't go through probate because she's a joint owner. If the wife dies, the husband doesn't go through probate. He's a joint owner. If they both die, if they've done nothing at all, the house just in their name, and they want the house to go to their 3 kids, well, if there's been nothing done, when the kids go to the county where they live and say, my mom and dad had a house on number 1 Main Street, they told us for the last 23 Christmases, we get the house. They've now passed away. We're heartbroken. But how do we get the house? Well, the county's going to say, well, first of all, we need proof your mom and dad are dead. Okay, well, here's their death certificates. Okay, so we see they've died. And then they say, well, let me ask you a question. The house is in Joe and Sally's name. Do you guys have do you guys have children, have any legal mechanism that says you get this house? And at that point, the kids would say, no, they just told us we get it. Well, the county's going to say, we're very sorry. We have to open a probate file. There is no beneficiary on this property. We don't know if the house was supposed to go to your dad's brother or to charity or your sister's cousin, or I'm sorry, your mom's cousin. So things have to be distributed with beneficiaries. Most people don't have a beneficiary deed on their house. You might not. But even if somebody has a beneficiary deed, we'll find this out, not to get into the weeds too much. But even if somebody has a beneficiary deed, if I'm the beneficiary designee on a house, my parents die, if I'm in a lawsuit, divorce, or a bankruptcy, it's going to be problematic to me because I'm in some type of legal situation. I might not get their house or only half of their house. So estate planning is very important. Again, many people on this call might not know a whole lot about it. That's our job, is to teach you. What we do is we do educational seminars. Let me ask you all this question. Who on this call would like to see more people with more assets and show them things they've never heard about before? That's what we do. Most people don't know about estate planning, so you're going to be able to educate these clients. The people who we invite to seminars, at least, are going to have assets. And number three, our process, our program, the solution you can offer your clients is unlike anything else in the industry. And you would have the exclusive in your area if you're doing seminars. Now, some of you guys don't want to do seminars. Some of you guys might be just an agent that does final expense, Medicare, doesn't do seminar. That's okay. We have a process where you can go help your clients also. So it fits for anybody, a seminar person or a non-seminar person. The most important thing is the education. So what I want to do is go through a series of slides that kind of explain what we do in a seminar. And again, for those of you who want to do seminars, we have a program all set up for it. It's perfect. It's turnkey. We provide the attorney and all the specialists that need to have happen. All you got to do is provide the seminar, deliver the message, and then do the intake interview, which I'll teach you as we go through the process. But if you're an agent who doesn't do seminars, you can still use our process. You would just use it as you go to somebody's house and explain it to them at their kitchen table as you would a final expense program or a Medicare supplement program, as long as they have the need for what you have. So I'm going to go do this. I'm going to share my screen. Bernard's going to always tell me if I'm out of line here or out of control, or he needs to input something, but I'm going to go ahead and go with this. If I can share my screen, and I'll probably screw this up, but hopefully everybody sees my screen. There it is. Okay, it popped up. So this is a typical, I would say 60% of what we do in a seminar. I can't show you the whole thing because we'd be here too long, but I kind of want to go here to give you guys a flavor, a taste of what happens in a seminar. What we do in a seminar is I show certain celebrities. That's Walter Cronkite. I go through this on the screen. That's Jacqueline Kennedy Onassis, Martin Luther King, Michael Jackson, Babe Ruth, Princess Di, Marilyn Monroe, Elvis Presley. All these people went through probate. They all died and they all went through probate because they didn't have a proper plan. Some of these people didn't plan at all, but they all went through probate. I've already told you guys there's a lot of Americans that go through probate. In fact, 230 a day in every state go through probate, but probate can be completely avoided with the proper plan. It's our job to educate our clients and the general public on why this is so important and how to have a solution. In the seminar, I'll bring up my bio. If you guys do a seminar, we will build this for you. It'll be your picture there, your name, and you'll have a bio here. And you'll talk about yourself in the seminar. Now, when I do a seminar, and this is pretty early in the seminar, I've already given the people in the audience the statistic, 250 people, 230 people a day go through probate in every state. A lot of people in the seminar, though, because we're only about 10 minutes in the seminar, think they're doing okay because they're naming beneficiaries on their IRA. And just so you guys know this, you might want to write this down. I was taught to tell my clients on an IRA, just list beneficiaries, the client will avoid probate. That's probably what you were taught, or that's what you know. That's all I did for 30 years. I've been in the business 38 years, though. The last 8 years, I've learned that there's 10 reasons not to name a beneficiary on an IRA. 10 things that can happen because of that strategy. So again, we talk about education. Once your clients know that, they're going to have their ears perked. You probably have your ears perked right now as an agent. What? 10 reasons not to do that. You probably don't know. Maybe we're going to talk about that a little bit today. Now, but what I do, because I'm going to grab their attention at the beginning of the seminar, I'll click on this slide here and I'll say, ladies and gentlemen, the reason I'm with you today is because when I was 18 years old, I was told I had cancer. I had 3 weeks to live. Now, that day was a very sad day in my life. It was concerning, but the one thing that was positive for me, was I had capacity. I picked my doctor, my hospital, my plan of treatment. I always ask people, I was away at college when this happened. What if I'd have been in a car accident? I'd have been in a coma, and my parents drove down to my college, 2 hours down to Columbia, Missouri. And I was in intensive care in a coma. Well, if my parents arrive at the hospital in Missouri and they don't have the proper documents, my parents will have zero control to make a decision for me. None. I would have just put my parents in what we call living probate. They'd have to go to court to be named the healthcare power of attorney. Most states are like that. Not all states, but most states are like that. So I always ask people in the seminar, how many people in this room right now have a single adult child over 18? And hands go up. I say, heaven forbid. I hope you don't get a call Saturday night at 2:30 in the morning. Your child's been in a car accident, because without the proper documents, there's a chance, and a very good chance, when you get to the hospital as the parent, you'll have no power either. Your child's over 18, they're an adult. They need to name somebody. Let me ask you this question also. How many of your clients right now have kids in their mid 40s that are married to somebody in their mid 40s? Well, what happens is what if somebody's son and daughter, somebody's son and wife, your client's son and their daughter-in-law are both in a car accident tonight? Well, your clients go to the hospital for their son, two people, your two clients go to the hospital for their son. The wife of the son, her two parents go to the hospital. We got four adults at the hospital. Nobody's got any documents. Guess what? Guess which one of the four adults have power? In most states, zero. We got two families going through probate. Your client's son and his wife and they're her parents. So again, these documents have to be done up front. Most people don't realize this, and we have problems. We are in the newspaper about this. We'll talk about that in the seminar. We give you an entire team. If you are doing seminars with our platform, this will be you right here in the center. And we provide all this team. There's 3 estate planning attorneys. There's an estate planning attorney, estate planning attorney, and estate planning attorney. This gentleman's a tax lawyer. Greg owns a trust company. This is the funding specialist. We'll talk a little bit about funding today, but you guys get an entire team provided by our organization that you can refer your clients to. With a one-time flat fee for the documents, your clients have access to all these people. So we make you guys look bigger. Here's a list of our attorneys: Ed Kaiser, Jennifer Serman, Sarah Lister, and Chelsea Keller. Ed Kaiser is the general counsel for Remax Results. Many of you on this call have heard of the company Remax Results Realty Company. It's a huge nationwide realty company. If you Google Ed Kaiser, you'll find out he's their #1 corporate attorney. He's their general counsel right there. He is the attorney on a lot of our cases because he believes in our platform so much. So we have a lot of credibility with our attorneys. Ed Kai's been an attorney for 10 years, magna cum laude, Wisconsin, Eau Claire, and then magna cum laude from William Mitchell College of Law in St. Paul, Minnesota. Howard and other firms, we provide a legal platform, tax, and financial. Now, again, in the seminar, where my picture is here on the right, that's where your picture will be. We want to build you up. We give you the legal platform. The tax thing we're working on with Jason, but we give you these platforms that you guys can plug into. Again, it makes you look bigger. You've got an attorney, you've got a tax person, and then this is you right here. We offer a free consultation. Now, here's what happens, guys. In a seminar, live seminar, when I get to this point right here, I say internet-based option, and I hold up a traditional trust book, and I pick somebody out in the crowd. I say, Joe, let me ask you a question. If you had a traditional book trust, if you had a traditional book trust, most trusts are done like this with paper. If you had a traditional book trust, Joe, how do you change a book trust, Joe? Well, Joe will look at me and go, I really don't know. Or he'll say, you got to call the attorney. I say, yeah, Joe, you're right. You got to call the attorney, Joe. But guess what? The good attorneys won't talk to you that day. It's going to be a week till you can go see the attorney. Once you get to the lawyer's office, he or she will say, well, you know what, Joe, I didn't know this, but you had a couple of grandkids and you changed your bank account, you bought a new piece of property, you downsized your house. And did you realize Michigan or Florida or Texas passed a couple of laws last year? Well, we got a lot of work to do, Joe. Yeah, tell you what, Joe, it's going to take me 4 hours to do all the work. You probably don't want to sit here for 4 hours. Why don't you just go home? I'm going to finish all the changes. I'll be done in about a week. When I get the changes out, I'm going to mail them to you, Joe. But before you leave, Joe, see Sarah at the front desk, Joe. You owe us $1,500. See, with a book trust, guys, the problem we have with this book trust is the client, number one, has no control. They can't change it, and they got to pay for every change. So in the seminar, I'll stand up and say, does anybody like that process? Does anybody want to have no control and have to pay for every change? The clients go, no. I say, fantastic. The reason I bring this up is when I talk about our internet-based option gives you control. See, our platform is digitized. For a one-time flat fee, the client can log into the estate plan. We've been around since 1985 and make any change they want to from wherever they are, whenever they want to. Unlimited changes are $95 a year. That's not the one-time flat fee. That's $95 a year to make changes. People love the ability to go make changes whenever they want to. Even if they need specialized help from the law firm, it's only $95 a year, one time, unlimited. People like that. I would just ask you on the call, wouldn't it be great to be able to log into your trust anytime you want to for $95 a year unlimited and get legal help if you need it? The answer is yes. So people love it. And then we talk about home of the estate plan. I hold the book up again when I click this. I say, what does a book trust cost? And somebody will yell out 3,000, 5,000, 10,000. I say, those are probably all good answers. It could cost that much. But remember this, guys, our girls, our ladies, anybody with a book trust, whether it's 3,000, 5,000, or 10,000, when the attorney actually quotes you the price, it's not the price. It's the initial cost to start it. It's not the price. Because the client has to pay for all the changes, there's no way to tell what a book trust is going to cost. In a seminar, I'll pick somebody out and say, hey, Margaret, if you get a book trust, the only way the attorney can tell you what the trust is going to cost is you got to tell the attorney when you're going to die, when your husband's going to die, who's going to die first, is anybody going to the nursing home, how many times your daughter are going to get married, how many grandkids you're going to have, how many great grandkids, how many times your son going to get divorced, are you going to change your bank account, buy a new car, are you going to get an inheritance, and how many laws is Texas going to change before you pass away? If you can tell the attorney all that now, they can come close, but it ain't $3, $5, or $10,000. It could be $20,000. Does anybody like that? And they say no. I say, great. The reason I bring it up, ladies and gentlemen, one of the reasons you want to come see us is we can offer a one-time flat fee for the documents, one-time flat fee, and you never pay again for documents the rest of your life. There's nothing that I know of exists in the entire country other than that. So you might want to circle a day and time right now on your questionnaire so we can call you tomorrow and have you come in for the free consultation. Then we partnered with Crawford Trust Company. I talk about Crawford Trust. I'm not going to go into detail, but we have a trust company relationship. If somebody does a trust, they have to name a successor trustee, which is the person, their son, our company, Crawford Trust, who runs their trust to become incapacitated or die. We have a relationship. We can show people to take that burden off their kids because I don't know if anybody in this call has ever settled in a state, but it's not a very fun process. It's tedious, time consuming. You got to become a fiduciary. You could be sued. You got to do tax returns. So we have a company that will do that for the client if they want us to do that. This is a very important article we show in the seminar. 64% of all Fortune 500 firms are Delaware incorporated. Now, a lot of you on this call know this. Some of you don't, but I'm going to go through this as I would in a seminar. I would say to the audience, some of you know this, some of you don't know this. Let's cover this. Does anybody know where the company Microsoft's home office is? And a bunch of hands will go up, and I'll pick on some. I say, well, tell me where the home office is. They'll say Washington State. I said, fantastic, you're right. Washington State. Microsoft's home office is in Redmond, Washington on the West Coast. But if you Google their company's incorporation, you'll find out that Microsoft is incorporated through Delaware on the East Coast. So is Boeing, AT&T, Coca-Cola, Del Monte Foods, Dell Computer, eBay, Amazon, Walmart, and General Motors. All incorporated through Delaware, even though they're not there. And the reason for this is called jurisdictional shopping. Please write down the term jurisdictional shopping. And they write it down. I say, big companies can incorporate anywhere they want to. That's their jurisdictional shopping right. However, everyday Americans like you and I have jurisdictional shopping privileges too. Let me prove it to you. Who in this room is a Michigan resident? Well, all those hands go up. Or Montana resident, or Missouri resident, or Florida resident. Wherever we are, the hands go up. I say, if you're a Michigan resident, isn't it true you could drive to Ohio and buy a car today? Yes. You could actually drive to Ohio and on Ohio soil enter an Ohio contract, even though you're a Michigan resident. Yes. The only reason you do that is because of jurisdictional shopping. And anybody in this call can drive to Missouri and buy my house, even though you might live in Texas, correct? You can buy property in Florida. You can jurisdictionally shop also as a United States citizen, no problem. The reason we bring this up is not because we're going to incorporate a business or because we're going to buy property, but we're going to talk about estate planning. Estate planning is no different. Just because you live in Texas doesn't mean you have to use Texas law when you do your trust. Just because you live in Michigan doesn't mean you have to use Michigan law when you do your trust, or Pennsylvania, or Idaho, or California. You can jurisdictionally shop for that also. The reason I bring this up, ladies and gentlemen, we've already done the research. This right here is the 10th annual domestic asset protection trust state rankings chart. This is the asset protection trust, but it piggybacks off Nevada law. Nevada law is ranked #1 in the United States when it comes to trust law. South Dakota, Ohio, Missouri, New Hampshire, Tennessee, Delaware, Arkansas. This is 2 years ago. This is on the internet. You can Google it when you get off this call. Google it. The next year is the 11th year. This was actually last year. whoops, the 11th year, 11th annual domestic asset, Nevada again, South Dakota, Ohio, Missouri, Nevada. And I tell the clients in the audience in the seminar, please write this down. You're probably wondering why Nevada is ranked number one. Here's why they're ranked number one. Write this down. Nevada is the only state in our country that has codified all the laws electronically, and they recognize e-signatures throughout the whole process. So using technology, Nevada can provide benefits to you that maybe Pennsylvania can, or Missouri can, or Michigan can, or Illinois, or Minnesota, or California. We can use Nevada law. You can use Nevada law just like you can buy a car in Ohio or buy property in Florida. It's not a big deal. So we want to make sure. The reason we bring this up is we can offer Nevada law. There's actually 8 reasons to use Nevada when you decide as your trust. When you come in for the free consultation, we'll talk about that. And then we get into how we're able to help you guys. How can we help you guys? What's better, a will or a trust? Can you grow your money with 100% protection? Tax planning strategies. Are you being taxed on Social Security? What if we could eliminate that or lower it? Can you retire tax-free? Is anybody talking about that? What if you can retire tax-free and you don't even know? You might want to come in because we can run the analysis. Maybe you can retire tax-free and financial strategies and growth. Then I go through why we're able to help you, why we're here. Let's go through this. How many people in the country do you think have a will? And I asked somebody in the audience, people yell at us, yell out 10%, 20%. I say it's actually 40%. 40% of the people in this country have a will based on this article. But then I tell the audience, write this down. If all you have is a will and nothing else, a will guarantees probate. A will is a horrible way to distribute assets. It guarantees your family probate if you have a will. A lot of people don't know that. So they find that out and they say, oh, I'm not doing enough. I need to do something more than a will. So I'm going to get a trust. How many people in our country have a trust? I asked for the audience to participate. I get things yelling at me, 12%, 20%, whatever. I say it's actually 17%. Whoops, that's skipped. It's actually 17%. And then I say this to them. A trust does not avoid probate either. A trust is a document that'll give you healthcare power of attorney, financial power of attorney. But as far as your title tangible assets, see what happens, ladies and gentlemen, you can go get a book trust like this done, spend $8,000, $10,000. If the law firm leaves the house, the rental property, your lake house, the bank accounts, your CD, your money market account, your RV in your name, they don't transfer that name to the trust name. When you die, although you have a book trust or you have paper that's notarized, your title tangible assets still go through probate. The trust does not avoid probate. What avoids probate is something called funding the trust. Please write down the word funding. Funding is nothing to do with money. Funding is just the retitlement of the asset in the trust name. We got to get your house out of your personal name into the trust name. The RV out of your personal name into the trust name. The bank accounts the same way. The rental property, your vehicles, things like that. So that's called funding. The problem most people have with this book situation, like I had in Missouri, or you might have in Michigan or Florida or California, Idaho, Illinois, Minnesota, is because we're using paper, we usually have to fund the trust by paper, by sending letters to the DMV, to the mortgage company, to the bank. It's a pain in the neck. It's time consuming, tedious, complicated. My experience has been most trusts aren't funded properly, and some trusts aren't funded at all. They're a waste of paper. They're a waste of money because the client's still going to go through probate. Most clients, my experience has been, don't know that. So when they find out about funding, I say funding is a problem. Today is already the 26th of April. If you went to get a book trust, the trust wouldn't even be done till probably the end of May. Then you got to fund the trust. You got to send letters out, which might take 4 to 12 weeks. You'd be lucky if your trust is done by July. The reason I bring that up, ladies and gentlemen, when I talked about Nevada law, and I pick somebody out in the crowd and I say, Sarah, let me ask you a question. If you come into the office and we use Nevada law, which we know you can, I'm not saying you should, I'm just saying you could, you might be worth $10 million, Sarah. If we use Nevada law, guess how quick I can fund your trust, Sarah? And she'll say, I don't know. I say 1 hour, Sarah. And then I go around the room, 1 hour, Joe, 1 hour, Becky, 1 hour, Sam. See, we can electronically assign assets to the trust using Nevada law. People love that. How can we do that? Because Nevada is the only state in our country that's codified all the laws electronically. So we can do things electronically. We don't got to mess with paper anymore. So people like that. Bernard, how are we doing? Do you want to take any questions now, or are we losing momentum, gaining momentum? Bernard, are you still here?
Yep, yep. Oh, go
Okay.
ahead, Scott. Keep going.
Okay, is everything okay? Okay, then I allude to an article, findings an article. Nearly half the people in this article thought estate planning is for the rich and famous. A lot of times when people think estate planning, they think of this big estate with the barbed wire fences and all this. Let me say this to you. I don't know, we have multiple people on the call, obviously, but the state of Michigan, the cutoff for probate, when you're a candidate for probate, is $15,000. Anybody in Michigan has an asset in their own name with 15 grand, they're a candidate for probate. In Missouri, it's 40,000. In Connecticut, it's 40,000. In Illinois, it's 100. In Texas, it's 75,000 cash, $100,000 property. California is the largest threshold for probate. It's only 156,000. You can't have a house under 156,000 in California. So most people are candidates for probate. This is a total fallacy. 25% of the people haven't spoken to their death about their own family. I understand that. People don't talk about it. 49% their assets say their assets aren't worth enough to do an estate plan. That's a total fallacy. 61% of people in this survey thought a will is enough to meet their estate plan needs, when in fact it guarantees probate. I'm here to tell you guys on this call, the public, your clients are totally uneducated, just like mine were. Mine were not educated until now. Every city I go to, people are not educated. 35%, whoops, let me get to this. 35, well, how come it's not working? Did I do something wrong, Bernard? Oh, there it is. Okay. 35% of all people in this article knew of somebody who died and the kids don't talk anymore. The cousin's mad at the sister because people didn't write anything down. So again, we talk about this, and our platform enables people to go in and do things whenever they want to from their home computer on a Sunday, Saturday, Tuesday night, unlike a book where you can't really do that, do a very good job of doing that. And 46% of people said they want to know more about estate planning. Think about that, guys. In our country and gals, 46% of all Americans want to know more about estate planning. This is a hot topic, guys. We're getting hundreds of people to come to our seminars. Estate planning. Why might you need an estate plan? I'll just go through these a couple times. Number one, a car accident. If you're incapacitated in a car accident, guys, and you don't have proper documents, depending on where you live, what state, your family can't make a decision for you. Might take a chance. Number two, beneficiary designations. I won't cover them both, but by naming beneficiaries, guys, I point out two reasons why you don't want to name beneficiaries on this slide. A beneficiary designation could cause probate and unintentional disinheritance of grandkids. When we get deeper into this, I'll cover those with you. I don't want to bore you too much today, but we go through that in the seminar. Number three, joint tenancy. A lot of your clients are putting their daughter, their son on their bank account and their house. This is a big problem. It's a big problem waiting to happen. See, if these two people who are retired put their daughter on the house, on their bank account in their house, which is what happened here as I go through this, parents put the child in their house in the bank account, and then 6 months later, their son-in-law wants a divorce, he could be party to their house and their bank account. How would you like to be in a situation where your client who's retired has to write the son-in-law a check for 200 grand out of their $400,000 house because they put their daughter on the house? See, they don't know that stuff. They don't know the risk. So we got to make sure they understand that. What if there's a lawsuit? What if this daughter is sued after a car accident? Well, the lawsuit might take the parents' house. As soon as they put their kids on their house, they assume their child's liability. That's not good. Nobody should be on your property, and you shouldn't be on anybody's property. With an estate plan, we can accomplish the goal with no risk. This is very risky. Once we cover these things in a seminar, people want to come see us. They've never been told this before. Getting back to beneficiaries, this lady has a large IRA. The daughter's right here. The daughter's making $50,000 a year. Well, the lady dies. She's got an IRA worth $200,000. The daughter takes a lump sum. This is taxable to the daughter. It's ordinary income to anybody other than a spouse or a disabled child. Okay, so this is ordinary income. Well, the daughter's already making $50,000 a year. When the mom died, she took the $200,000. She made $200,000 plus her $250,000. That put in the 32% tax bracket. She lost 64 grand. The daughter gets 136,000. In the seminar, I asked people, is it your intention for your children to pay the most possible taxes? No. I said, we got to come in and see us. We can fix this problem. A beneficiary designation is this waiting to happen because most kids take a lump sum. Although they can take it over 10 years, kids don't do that. I've been in the business 38 years. Kids don't take 10 years. They take lump sums, and they're going to get smashed by taxes. Parents don't like that, but they don't have any other answer because their broker or their insurance agent just put a beneficiary in there. So you can build a wedge between the competition by doing this. Here's the other problem. I hope you guys know this. I didn't know it 10 years ago, but when you're writing life insurance, an annuity, a brokerage account, whatever you're doing, um, a beneficiary designation cannot be stopped. It can only be delayed, not stopped. Let me give you an example. I had a client last year, her name is Margaret. For 13 years, I told this lady, Margaret, you got to get an estate plan. No, 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 Scott, I got beneficiaries. I'm okay. Well, guess what? Last February, over a year ago now, last February, February 2023, the lady dies. The daughter's the beneficiary. The insurance company writes the letter to the daughter saying, we understand your mom passed away. Here's the beneficiary information. How do you want to take your payment? The daughter goes, I don't want it. I'm going through a divorce. The insurance company goes, okay, we can delay it. Okay, let's delay it. December 1st last year, the insurance company calls and says, Scott, we got to get rid of this. We got to get it off the books. We got $500,000. Does the daughter want the money or should we send it to Missouri unclaimed property? I said, I don't know. Let me call the daughter. Hey, daughter, what do you want to do? They're going to send the money to Missouri unclaimed property or to you. The daughter goes, send it to me. Now, I don't know what happened. I'm not privy to that. But the son-in-law who's in the divorce will have a right to make an argument to take half that money. I don't think that's the parent's intention. But remember, if the beneficiary designation cannot be stopped, only delayed, anybody's in a lawsuit or bankruptcy when their parents die has a potential problem. They might not get anything. So here we are telling people, beneficiary name it, you'll be okay. Well, there's 10 reasons not to do that, guys. I just covered a couple of them. We'll cover that in detail once you're ready to go. Scenario 4, could the IRA cause a divorce? Well, let's say the parent has a $500,000 IRA and they die. The daughter's the beneficiary, right? So she takes $500,000. She pays the taxes, ends up with $300,000. She thinks everything's okay. So she puts the $300,000 in a joint bank account with her husband. That's the perfect time for the husband to say, you know what, Sarah, you've been a great wife, but the kids are grown now and I really don't want to be married anymore. Well, the money's in a joint bank account. It's marital property. He can make a pretty good argument that half that money's his. Do you think your clients want to pay off their son-in-law to divorce the daughter possibly? No, but that's a beneficiary designation. See what happens, guys? When you explain this stuff in the seminar, people want to come see you because they've never been told this stuff before. And they want to take action because they don't want the money going to the son-in-law or daughter-in-law. Think about it in your own situation. You don't want that happening in your family. So you're going to want to come see us. 136,000 in this example, half goes to the son-in-law who just divorced your daughter. That's not good. Number 4, IRA benefit. We'll talk about this later. I don't want to bore you with this. Everybody has an IRA, should have an IRA beneficiary trust. When I was in Michigan, we did the seminar. We did two seminars when I was in Michigan. Tuesday night, Thursday night. Nobody knew what an IRA beneficiary trust was. Remember this, guys. When I was in Michigan, people came to that seminar that have assets. They're not broke. They have advisors who are not stupid. Their advisors are not stupid, but nobody knew about this document. This is the document that protects the policyholders' kids against a lawsuit, divorce, taxes, and unintentional disinheritance. All your clients need to know about this. In Michigan, nobody knew about it in our 2 seminars. I'm going to go out on a limb here and say your clients don't know about this. This is another thing you can show them to benefit them. Once your clients know this information, know that you want to talk that you know what you're talking about, you're going to get a ton of referrals. Does anybody on this call want to get 20, 30 referrals a week? Well, that's what our platform does because you're the only person that's ever explained this to people. You're not like everybody else just selling annuities, final expense, Medicare, life insurance. Everybody does that. You have a situation where you can educate people on stuff they know nothing about. All of a sudden, you're the expert, and they want you to talk to their daughter and their sister and their cousin and their neighbor. It's a great way to get referrals because you got an educational process. If anybody in the seminar has a special needs situation, we have an expert if somebody has special needs children. I don't know if you guys know this, but you guys are probably selling a lot of life insurance and IRA annuities. I don't know if you know this, but when you name a spouse as the beneficiary in an IRA annuity or 401k, whatever you guys do, that's fine. But if this is your client right here, you see my cursor, that's the gentleman in the coma. The wife is the beneficiary, but the guy's not dead. He's just in a coma. If your spouse is in a coma or becomes incapacitated and your spouse has an IRA, What access we have that money without the proper documents? I'm here to tell you guys, it's nationwide. Zero. If you have a client, you have two people that are married, you're taking care of them, and the guy has a $600,000 annuity or a $100,000 annuity, and he has a heart attack or has a car accident, and the wife calls you and asks, what's in Herb's annuity? You cannot disclose that. If you do, you can lose your license. Without a financial power of attorney, if the guy's not dead, you can't give the wife information if it's in his name only, or vice versa in the wife's name. Now, even if you break the law, when you send the withdrawal form to the wife, she signs it and sends it to the insurance company. The company won't release the money unless there's a financial power of attorney enclosed. So we're sitting there, you're trying to, and I know you guys do a great job. You're doing a great job for your client's health, but in fact, you might be putting them in harm's way. It's not going to be a good conversation when you say, I'm sorry, Susan, I didn't know this, but because the annuity is just in your husband's name, we can't give you any money without proper documents. Everybody needs to have a financial power of attorney. Think of your own situation as an insurance agent. How many of you are married right now that have an IRA or your spouse has an IRA? You're in the same situation right now without a financial power of attorney. So it's universal. Everybody needs this information. This is a single adult child over 18. Heaven forbid you get a call. Don't be in that situation. We'll talk about that in the seminar. Then we said proper estate planning can handle all this. We want you to come into the seminar. We want you to come in for the free consultation because we can address all these things. With that being said, Bernard, I can go on and on. I think we kind of hit it pretty good. I don't want to bore anybody, but I think I touched on why they need, the people on the call need to be aware of this stuff because we can provide the system turnkey for anybody that wants to start educating not only their clients, but the general public in their area. Here's what happens, guys. Write this down. Just write this down. If you do a mailing for a seminar, a low response would be 80 people respond. We do a 6,000 piece mailing, 6,000 piece mailing. 80 people respond. Now the mailing costs $5,000. So put down, I spent $5,000. 80 people have signed up. Of the 80 people who sign up, 90% will show up. So you got 72 people coming to see you over a 2 or 3 day event. Monday night, Tuesday night, Thursday night, Tuesday, whatever, we'll figure it out. 2 or 3 events, but you got 80 people coming. 72 people will show up. Out of the 72 people, 65% are going to be buying units, meaning some people come by themselves, some people are married. But out of the 72, if 65% are buying units, you're going to have 47 buying units at your accumulated events there, 47 people. We usually set about 70% appointments. So we'll have 33 appointments, that 33 buying units that want an appointment. We have to be persistent and aggressive when we call these people the next day because they're going to forget what you said if you call them a day later, 2 days later. You got to call them. When I have a seminar, if I have a seminar Tuesday night, I'm calling these people Wednesday morning at 8:30, 10:30, 12:30, 2:30, 4:30, 6:30, and 8:30 at night. I've got to get them in the office because they're going to forget what I told them. They're going to talk to another attorney who says you can't do that. It sounds hokey. Or they're going to talk to their mechanic. I'm just telling you, I've been doing this for over 8.5 years. You got to call them right away. Now, if you do a good job calling, those 33 people, 80% will come in the office. We're going to lose 20%. So now you got 26 appointments. 33 times 80% is 26. We got 26 people, 26 buying units coming into your office. Of the 26 buying units, there's an intake interview, which we teach how to do that. It's a 1-hour consultation, how to do this interview. And we'll train you how to do this. Done properly, 70% of all the people who come into the office should move forward with the estate plan, which is what I'm talking about. The revocable living trust provided by integrated trust systems that you guys can offer. So now you got 18 new clients. Of the 18 new clients, you'll get paid a fee, an advisor support fee on those 18 new clients, which will help offset your 5,000 mailing costs. What you get paid is up to Jason. I can't answer that question, okay? But I know you can get paid on each trust implementation to offset your mailing costs. Now, what happens is once they enroll in the platform, you will set up step 2, which is their funding appointment. We've got to get their assets in the trust. We have somebody who does that on our team. You don't have to do that. You just have to collect the client's copies of their property, bank accounts, IRA, annuity, life insurance, card titles. We got it all written down, guys. Don't worry about it. Their client gives you that stuff, copy that information. You get it to the funding team. Then the funding team calls your clients. We set up the appointment for 10 days later. So now that's passed on. So after I implement their trust today, I'm probably not going to see the client for 3 or 4 weeks because they got to have their funding call. Then we have a call with somebody else on our staff who asks the client about their property distribution and their IRA distribution. Then each client has an attorney review. Once those steps are completed, which you're copied in an email each step, then you call the client, have them come in for step 5 when you notarize their documents, review their trust, and then you start talking about the insurance products you offer. But here's the key, write this down. You have 18 new clients. My experience has been the average person who comes in has about $400,000 in assets. Now, it might be a little higher, a little lower wherever you live. In Missouri, we're about average, about $400,000. So if I have 18 new clients that I've accumulated in this seminar round, if I know they have about 400,000 of assets, each of them, 18 times 400 is 7.2 million. If I just get 15% of 7.2 million, that's $1 million in annuity premium. I don't know what you guys make. Let's just say it's 4% on annuities. That's $40,000. Some of you do AUM, some of you do life insurance, whatever. But the average seminar should produce anywhere from 30 to 40,000 in revenue for you each time. So what we try to have advisors do is do 7 mailings a year. 7 mailings a year times 5,000. You'll spend 35,000 in mailing costs, but you should make about 300,000 in commissions. Anybody trade 35,000 for 300,000? I think most people would. It's going to take a little work. Yeah, you got to learn some things. Yeah, you got to work hard. Not easy. Anybody doesn't want to work hard and have an easy go, you probably shouldn't be in the insurance business. Okay. But again, we can't give this to everybody, only those people who really want to, commit to this and also have the training, let me teach you, then we're fine. Nobody fails if they listen to what I say. I just ask you to do what I do, say what I say, you'll be fine. It's proven turnkey. Everywhere we go is successful. We have no problems at all. The time we have problems is somebody thinks they're too smart, says, hey, Scott, I kind of want to do it this way. Don't be that person. I don't got time to do it your way. This works. Let's plug you into the system, get some results. After you're doing well, you're making 5, 6, 700,000 a year. Maybe you can change a few things. But in the beginning, let's just get you off to a good start. That would be my suggestion. All right, next slide. We cover what is probate is. We cover this, like this is Missouri. We cover what probate is. When we went to Michigan, we changed it. We had the Missouri probate. I show them this in the seminar. If somebody has a $400,000 house in Missouri, they don't have an estate plan, and that thing goes through probate, the fee is $23,000. Our trust is $2,700. I don't tell them that at the seminar, but I'm telling you, our entire estate plan that keeps them out of probate provides a financial power of attorney, healthcare power of attorney, living will, all the documents they need for 2 people is $2,700 and eliminates this $23,000. So it's a very, very good situation for a client. But I show them this slide in the seminar. I also say, where do you want your money to go? To state of Missouri or your kids? If you want to go to your kids, you got to come in for the free consultation. The first step in getting the stuff to your family is coming in for the free consultation. If you don't come in, you're probably going to procrastinate. You're going to end up over here. Don't do that. Number 2, most states have a delay, which is called an automatic temporary injunction of 6 months. Michigan has it. So does Missouri. So does Illinois. I just left Connecticut. They do too. It's usually 6 months. If somebody's house goes through probate, if you're on this call and you're in your 30s and 40s, your parents are in their 60s and 70s, if your mom and dad die, your mom dies and she's the only owner of the property, and it goes through probate, you can't sell the house. It's got to be in probate for 6 months. I always ask people, who's going to pay the house payment? In the seminar, I say, I know who's going to pay it. Your most successful child is going to pay the house payment for 6 months. And guess what? They never get the money back, and your kids don't talk for 5 Christmases because you didn't come in to see me. Don't do that to your family. Is it your intention to leave an emotional or financial burden on your family? If it's not, you need to come in and see us. What if your house is paid off? Still got to pay the water bill and the gas bill, electric. Who's going to pay those? What about the taxes? What if you die in October? Well, 6 months from October is April. You'll be in probate till April. What comes due in December? The real estate. Who's going to pay that one? If the real estate tax bill is 4,000 or 10,000, why would I, as your son, pay the real estate tax when I'm not guaranteed the probate judge is going to even give me the house? Why would I risk that money? I'm not going to risk the money. And the house might go into foreclosure. So again, these are all exposures for not doing anything. Once it goes to probate, it's public record. Probate is a Latin term that means to prove. It's public record. Anything that goes through probate goes in most cities, a prominent newspaper 3 consecutive weekends. Check out your newspaper, guys. But it's worse than that. When you get off this call, go to your state's CaseNet. Go to casenet.com and put in your state's probate, and the probate cases are right there. You don't even got to court anymore to make a claim. Anybody can test your property that goes through probate. A will guarantees probate. That's all you have. We show this slide in the seminar. All your assets are inventoried through the probate court. There's costs. We estimate about 10%. Because most people don't do tax mitigation. We'll talk about this separately. Most people leave their IRA to their kids. Well, their kids pay 30% of the IRA because they took a lump sum. Most families give their kids about 60%. If you're okay with this, don't come see us, is what I say in the seminar. If you don't like this, let's develop a strategy. Revocable living trust. We can wipe this out because we're going to fund your trust. This, we can't guarantee you this. We can't get everybody to 100%, but we can get you to 78, 82, 87, 90. Some people will get to 100, not everybody, but come in. Let's see what we can do for you. And we talk about estate planning non-planners. Elvis Presley dies with $10 million in his estate. 7.3 went to probate because all the Memphis Mafia guys, the 46 guys in his posse started fighting. 73% to probate. Howard Hughes dies. His estate took 7 years to settle. Michael Jackson, 3 kids, 2 ex-wives, mother went to probate court, 7 years to settle. Abraham Lincoln was an attorney, had nothing. He went to probate. Dr. Martin Luther King, 45 years in probate. We all know Prince died about 8 years ago. So Prince dies in Minnesota. He died in an elevator, 57 years old. He didn't know that was going to happen that day, but he died and he had nothing planned. So his whole entire estate went through probate. He's worth $316 million. It was all frozen. Minnesota has a 6-month automatic temporary injunction also. So the comedian George Lopez, his friend, had to loan the family $20,000 for the burial. Don't tell me it does not happen. We know it happens. Just don't let it happen to your clients. You now have a solution and a lot of great information to share. Probate's not the problem. Probate's a choice. Probate's because of lack of education or both. But probate's 100% avoidable. We'll cover this in the seminar. And we've covered the parties involved in a trust. Here you are, Mr. and Mrs. Jones. The problem is you got property in your name. We got to get a trust done. If you go anywhere else, it's not enough to pay the attorney. It's not enough to pay us. We got to fund the trust. We got to get the stuff in the trust. If you go anywhere else, it's probably 4 to 12 weeks. If you let us do it, we'll do it in about an hour. As soon as we get your documents, we'll put that stuff in the trust. Because of that, when you die, because the stuff's in the trust, it goes to your beneficiaries. If you want that to happen, thank you for your time tonight. Please circle a day and time, turn in your sheet, and we'll call you tomorrow for the free consultation. That's the seminar presentation. It takes an hour and 15 minutes. We can show you how to do that. Or if you're not a seminar person, that's okay. We can show you a condensed version of how to explain this to somebody one-on-one at their home and still get into the situation. So bottom line, guys, it's the most effective prospecting system in the country. Not product, but prospecting. It'll put you in front of a lot of people, increase your income. With that being said, Bernard, you would open up for questions. I'm ready.
Yep, folks, actually a great presentation from Scott. Actually, I love hearing it each time, and it actually every time I hear it, it helps me more because just a few of us is also a part of the program with Scott. Folks, you guys have any questions for Scott? I mean, I know you do, so just type them in.
No question.
Okay. So here, this is what we'll do. Now, after we get off of here, maybe in about an hour or so, I'll give everyone a call that attended this webinar. See if you have any questions. If I can't answer them, I'll if it's okay, we can have them give you a call, Scott.
Yeah, heck yeah. How many
Yeah.
people are on the call, Bernard? 12?
Okay, let's see what we got here. We have one question. Brad, actually, good question, Brad. What if someone already has a trust?
Great question. That's your best prospect. Because somebody already has a trust. Number one, they've already experienced they can't change it. Remember this with a book trust, the client can't change it. They got to go see the attorney in most cases. You can't white something out in a trust, line it out, initial it right in the margin. That's one problem. Number two, every time they go to get it changed, they got to pay a fee in most cases. Number three, it's probably not funded. Remember, if somebody has a trust, it doesn't mean they're going to avoid probate. They've got to retitle their assets in the trust name. Most people don't even know about that. I have a radio show in St. Louis. People call me every week, Scott, what's funding? Man, I've had a trust for 10 years. Nobody talked to me about that. Just because you have a book trust doesn't mean you're going to avoid probate. It's got to be funded. The other thing we have to realize this, if somebody has a trust, if you live in Michigan or Missouri or Florida, when somebody has a book trust, when a law changes, how does the client who owns the trust know when a law changes? The answer is most of the time they don't. But when the attorney calls them, guess who pays for the change? The client. See, the cool thing about our platform is all that's erased. Number one, we have a one-time flat fee. The client doesn't pay except one time for the documents, then $95 a year. Number two, we fund the trust. Number four, they can change it. And when a law changes, we can update their trust at no cost immediately when a law changes. So somebody who has a book trust, if you compare that to what they have, they're going to want to do business with you because they've already seen the problem. If that makes any sense.
All right, we have one more question from Mr. Harris. Where can I find your radio show and podcast?
Okay, so my website, everybody, is PEIP. So Paul, Edward, Igloo, Paul, STL. Sam, Tom, Lewis. PEIPSTL.com. Go to my website. At the top bar, you'll see radio. Click on that button, and you'll have access to all the radio shows. There's other information on there. There's other information on there too.
All right, folks, do we have any other questions for Scott? Okay. All right.
Okay. If anybody wants to increase their income and educate their clients in a way nobody else is doing, that this program would be for them. And just so you guys know, we're having success all over the country. I said 80 people sign up. It's usually over 100. I was going low, just so you guys know. But yeah, Bernard, let me know if there's anybody we can help out, and we'll go from there. I appreciate everybody's time today. Hopefully everybody has a great weekend, and we'll talk next time, Bernard. Okay, thank you.
All right, thanks again, Scott. Like I said, I'll reach out to everybody. So we'll, and those that are interested, I'll get your names, phone numbers, contact information, and then see if we can make it happen for you. So folks, enjoy your draft day weekend here in Detroit. Again, thank you for coming out, and see you later. All right,
Bernard. Thanks,
take
Bernard.
care,
Thanks,
Scott.
everybody. Thank
All
you,
right.
guys. Bye-bye. Take care. Thank you.